Hello, Monica.
Yes, ma'am.
I'm audible, visible.
Yes, ma'am, you're audible. You're visible also, ma'am.
Hello everyone. We are going to start the panel discussion in 2 minutes.
Pallavi, am I audible?
Yes, Professor.
Yes, sir.
You're
You
audible.
Fine.
Pallavi, have all the participants and panelists joined?
They're still joining, ma'am.
You are not audible, Pallavi.
Hello, am I audible?
Yes, now you're audible.
Yes, ma'am. They're still joining.
Okay.
Good afternoon, everyone. Distinguished guests, esteemed faculty, dedicated students, and all our virtual attendees. Myself, Pallavi Kashyap, the student co-convener of CEDRIL. It is my pleasure to invite Mrs. Monica Kotial, ma'am, the esteemed faculty convener of CEDRIL, for the welcome speech.
Thank you, Pallavi. Good afternoon, everyone, and a very warm welcome to this highly anticipated panel discussion organized by Center of Excellence in Alternative Dispute Resolution, the ICFI University, Dehradun. I would like to begin by acknowledging the presence of our respected Dean Sir of ICFI Law School, Professor Dr. Tapan Kumar Chandola, our Associate Dean, Dr. Monica Kharola, our faculty, uh, dedicated faculty members, our enthusiastic students, and all the participants who joined with us today. It is indeed an honor to have you all here. I, Monica Kotial, the convener, would like to extend a special welcome to our esteemed panelist, retired Judge of Supreme Court, Justice Hemant Gupta, advocates of renowned legal firms, Ms. Reshma, Mr. Sahil, Ms. Shruti, Mr. Param, whose expertise will undoubtedly enrich our discussion today. We deeply appreciate you all, sir, sir and ma'am, that on a weekend you have given your precious time to be part of this event. This session has been carefully designed to foster and robust exchange of ideas and perspectives. We will explore various dimensions of commercial arbitration, from its critical role in alleviating the burden on our courts to its impact on the broader justice delivery system. We will also look into the evolving trends and future directions of commercial arbitration, both within India and at a global stage. I encourage all participants to actively involve, engage with the panel, ask questions, and share your own views, as this is a unique opportunity to learn and to interact from most respected figures in the legal profession. Without further ado, I would like to officially commence our session. I would request our student co-convener, Ms. Pallavi Kashyap, to proceed the session further. Over to you, Pallavi. Pallavi, am I audible to you?
Yes, ma'am. Thank you for your kind words, ma'am. Now, I would like to invite the Dean, Professor Dr. Tapan Kumar Chandola, sir.
Thank you, Ms. Pallavi. Uh, I would like to begin this session by welcoming all the august panelists right from Justice Hemant Gupta, retired Judge, Supreme Court of India, currently Chairperson of Indian International Arbitration Center. Sir, we welcome you all from the core of our heart, and also we extend our gratitude for sparing time for all of us, sir. Also, I would like to welcome Ms. Reshma, founding partner of Neom Legal and in-house legal team member at Abu Dhabi National Oil Company. Ma'am, we welcome you from the core of our heart. Thank you again for sparing precious time for us. Also, we would like to welcome Ms. Shruti, partner at Shardul Amarchand Mangaldas and Company. We welcome you, madam. Mr. Sahil Narang, partner at Khetan and Company. Sir, we welcome you on the behalf of the entire ICFI family. Mr. Param Bhamra, founding partner of Mediate Guru. Sir, we also welcome you. And I also extend again my thanks to all of you, our gratitude for sparing time in the weekend to this very enlightening and most expected and awaited session on the topic promoting the effectiveness of commercial arbitration. We all know the gravity of this discussion, this topic. While international commercial arbitration is becoming progressively judicialized in the international courts, there is a current trend, an opposite trend where the arbitration is becoming a bit less popular amongst the parties. Though we know that arbitration is a part of alternative dispute resolution, it comes as a part of which promises speedy disposal, and also it talks about cutting the long costs while going in with the legal battles in due course of the commercial transactions. Still, the familiarity to the prospective litigants, it is essential that the awareness as well as the effectiveness along with the awareness should be optimal. Also, the aspect pertaining to the academic literature of the commercial arbitration, it is very much seen and felt that the academic literature worldwide that has a proliferation of international commercial courts, and it also includes their innovative features. Saying this, arbitration is one of the main drivers behind the establishment of commercial courts, and the objective of it cannot be underdetermined at any cost, at any level. Saying this, the current discussion which has been kept for today is of profound importance. So we are all looking forward towards having a very intellectual and very meaningful discussion on this topic. As far as the ICFI University is concerned, I would just like to give a small glimpse of our university. It's a society comprising of 11 campuses and 9 B schools. So it's a big ICFI family of 20 campuses. And the ICFI Law School, Dehradun, was established in 2003. And since then, it is striving for academic excellence. And this current event is just a very small step with the kind support of you all out there. And we hope that with the encouragement and the kind of support which we have received, we are receiving, we have received, and we are hopeful that we will receive in our future academic endeavors. Definitely, we will meet the academic excellence, and whatever small bit we can contribute in achieving the pinnacle of academic excellence, We promise that definitely we will do that, and your kind support would always be solicited. So again, I welcome all the panelists. I welcome all my professors, including Professor Dr. Arun Kumar Singh, Dr. Monica Harula Madam, and all my entire faculty and all the esteemed listeners, participants, and I would request all of them to take the maximum benefit out of it with this illustrious panelists. So, not delaying much, I would like to again welcome you all, and over to you, Pallavi, to take the session forward. Thank you. Thank you all.
Thank you, sir, for your inspiring and insightful words. Now, I would like to invite the Assistant Dean, Dr. Monica Kharola, ma'am.
And thank you. I firstly would like to extend a warm welcome to all the panelists, beginning with Justice Hemant Gupta, sir, Judge, Supreme Court of India, retired, Miss Reshma, Mr. Sahil, Miss Shruti, Mr. Param, and our respected Dean, faculties, students, advocates, and all those who are present here today to be and listen to the panel members on a discussion on a topic which is of immense importance. I have been asked to tell you something about ICFI Law School. And ICFI University, Dehradun, which started in 2003, started the ICFI Law School in 2004. We've had around a number of alumni who are today doing extremely well, because the focus of ICFI Law School is to hone the professional knowledge of our students, giving them the opportunity to be exposed to not only the theoretical aspects of the various law subjects, management subjects, humanities, but also to give them an external exposure to practical aspects of these subjects. And in this endeavor of ours to make our students well versed with the law and its application, we continue to have activities.
Ma'am, you are mute. You are on mute, ma'am.
Hello?
Unmute yourself.
Hello, Monica, am I audible?
Yes, you're audible now, ma'am.
Yeah, please check if someone, if it is all right. Okay, so I'm sorry for that disturbance. A little about the center which is conducting this activity. This is the Center for Excellence in Alternative Dispute Resolution Law. It is among the 8 centers that we have constituted in ICFI Law School, and it is very ably being guided by Associate Professor Dr. Sushant Kumar Shadangi and Miss Monica Kotyal, Assistant Professor at ICFI Law School. And both of them are being helped, and with the help of the placement coordinator, Mr. Divakar Das, they have been conducting these national and international events very successfully, which are helping to make ADR more effective, and students are able to understand its implications and its application. The center is not only promoting these discourses, but is also taking up research work. And I'm sure that in the days to come, we will have certain publications which will be there for everyone to see as landmark achievements for the center. The center is also not only assisted by the faculties, but the students play a very strong and proactive role, and they are very enthusiastic and committed to making this center effective. And I'm sure that this program also will be remembered for having achieved its target audience. Thank you. Over to you.
Thank you, ma'am, for your kind words. Now, I would like to invite the faculty co-convener of CEDRL, Mr. Divakar Das, sir.
Thank you, Pallavi. Am I audible?
Yes, sir.
Yes,
You're
sir.
audible.
The Center for Excellence in Alternative Dispute Resolution has been instituted within the framework of ICPI Law School, the ICPI University Dehradun in the year 2021, under the valuable guidance of Associate Professor Dr. Sushant Kumar Sadangi, Assistant Professor Ms. Monica Kotial, and myself, Divakar Das, the Placement Coordinator of ICPI Law School, the ICPI University Dehradun. The center adheres to the university's guidelines and regulations, dedicating to the fostering education on alternative dispute resolution law. The center emphasizes a comprehensive research-driven exploration of this field. The logo of the center bears the Sanskrit phrase "Bakshyami te hitam" that has been taken from Srimad Bhagavad Gita, which emphasizing and that can be explained as "I speak for your benefit." This encapsulates the core ethos of the center, emphasizing its commitment to resolving disputes with a focus on the well-being and interest of all the parties involved. Committed to the convergence of academia and expert perspective, the center is poised to embark on innovative projects that showcase the intersection of theory and practice in India. Through its advocacy, research initiatives, and policy-oriented discussions, the center seeks to facilitate a nuanced understanding of ADR law, providing a platform for individuals to enhance their knowledge in this dynamic legal domain. The center envisions becoming a hub for fostering excellence in ADR, promoting informed discourse, and contributing to the broader legal landscape. The Center for Excellence Alternative Dispute Resolution Law, that is CEDRL, is a dynamic and proactive student body comprising enthusiastic and committed students from BBLLB Honors, BLLB Honors, LLB Trial Program, dedicated to promoting peaceful conflict resolution within the academic environment. I, Divakar Das, welcome you all. Thank you, ma'am. Over to you.
Thank you for joining us, sir. Now, I would like to call the student convener, Ms. Suyesh Singh, who will guide us through the introduction of our esteemed panel.
Thank you so much, Pallavi. Am I audible to you?
Yes, you're audible.
Thank you so much. It is my distinct honor to introduce the distinguished panelists for today's virtual national panel discussion on promoting the effectiveness of culture of commercial arbitration. Each of these experts bring a wealth of knowledge and experience that is pivotal to our discussion. First, let us welcome Justice Hemant Gupta, sir. Sir is the chairperson of Indian International Arbitration Center and retired Supreme Court judge. A fellow of Chartered Institute of Arbitrator, he has a remarkable career dedicated to advancing arbitration in India. His contribution continued to shape the future of legal practice both nationally and internationally. We are truly honored to have you with us today, sir. Thank you so much. Next, I'm pleased to introduce Ms. Reshma Ugara, ma'am, as a leader of Neon Legal and a key member in-house legal team at Abu Dhabi National Oil Company. She is an experienced arbitrator and licensed attorney registered in UAE, England, and Wales and Mauritius. She is also a fellow of Chartered Institute of Arbitrator UAE branch, making her a significant force in the global arbitration community. Thank you so much, ma'am, for joining us today. We are also privileged to have with us Mr. Sahil Narang, sir, a partner at Khaitan & Co. with over 14 years of experience in commercial litigation and arbitration. As an advocate on record of Supreme Court and a newly appointed arbitrator with Indian Dispute Resolution Council. She is renowned by his strategic approach to resolve complex disputes across various sectors. We are grateful for your presence today, sir.
Thank you. Thank you.
Joining us as well is Ms. Shruti Khanijoy, a partner at Sardulya Amarchand Mangaldas & Co., with over a decade of experience in international arbitration and commercial dispute, and as an alumni of University of Cambridge. Ma'am has represented significant cases in India, London, Singapore, and beyond. As a specialist mediator at the Singapore International Mediation Center, she plays a crucial role in global arbitration arena. We are dedicated to have you with us, ma'am. Thank you so much. Last but certainly not least, we welcome Mr. Param Bhamrat, the founding partner of Mediate Guru and today's moderator of the panel discussion. A prominent figure in the international arbitration, sir is passionate about alternative dispute resolution through Mediate Guru. He connects experienced mediator and arbitrator with emerging legal professionals around the world. His affiliation with leading arbitrators, certain globally, and his dedication to mentioning the next generation for legal talent are truly commendable. We are fortunate to have you with us, sir, and look forward to your moderation for this panel discussion. Thank you so much. And now over to you, Param, sir.
Thank you so much, Suyash, for the wonderful introduction. And thank you to the ITFA University for having me here, along with all our honored panelists. And so, good afternoon, everyone. It is my honor and privilege to welcome you to this panel discussion on promoting the effectiveness of issues in the field of arbitration, a practice which I believe that has become central to resolving commercial disputes in our increasing complex global landscape. Commercial arbitrations, as we all know, has grown to be a cornerstone of dispute resolution along with mediation. However, with this growth comes the necessity to continuously evaluate and improve its effectiveness, confront the challenges it faces, and explore whether institutionalizing arbitration can serve as a viable solution to these challenges or not. Our discussion today will delve into these sub-themes with insights from our esteemed panelists, each of whom brings a wealth of knowledge and experience to the table. And we will be putting the conference in 3 sub-themes. Sub-theme 1 would be the effectiveness of commercial arbitration. Theme 2 would be challenges faced by commercial arbitration. And sub-theme 3 would be will institutionalized arbitration address those challenges. So our first sub-theme focuses on the effectiveness of commercial arbitration. And we begin by posing the question to Justice Hemant Gupta sir, who with his vast experience, both as a Supreme Court Justice and now as a chairperson of India International Arbitration Center, has a unique perspective on the role of judicial intervention. Justice Gupta sir, how do you view the role of judicial intervention in enhancing the effectiveness of commercial arbitration in India? And are there any specific measures that could further empower arbitration tribunals while ensuring fairness? So please. Sir, you are on mute right now.
Yeah, thank you, Param.
Yes,
I think
thank you.
I can hear. You can hear me.
Yes, sir. Yes.
You are right. The judicial intervention has brought positive changes in the Indian arbitration ecosystem, but there are certain exceptions also. Like I will give example of recent judgment in Annan global case where the stamp duty was said to be imposable on the agreement containing arbitration clause. The self-corrective mechanism has corrected that judgment in a record time of less than 6 months. This is something which can happen in our effective judicial system. We have again, judicial intervention in respect of grounds of challenge of arbitration award, like arbitration, the ground of challenge of arbitration award. The law says, the BEAR Act says, that the fundamental policy of Indian law is a ground of challenging the arbitration award. But what is fundamental policy is again subject matter of interpretation. Supreme Court said that patent illegality will be ground of challenge. The patent illegality is again very subjective. In one case, the bench can say that it's patently illegal. In other case, it can take the different view. Because in our system of judicial dispensation, it is judge-made. A judge is the final arbiter of the issues which arise before the court. So therefore, the court has more or less taken a consistent view to promote arbitration. Some exceptions here and there, are there, but broadly, the court has taken into consideration that part. One thing, another judgment which is relevant is group of companies, Cokes and Kings. That is another positive judgment to reduce the multiple litigation regarding the same group of companies. This is a welcome step. I would like to say something about the 7 judges bench judgment in State Bank of Patiala versus Patel Engineering, where the question which overruled the earlier constitutional bench judgment in Konkan Railways to say that the power exercised by the court under section 11(6) is the judicial power and not administrative power. I think I have a different view, maybe, but I would like to share with you. It is subject matter of debate. If the institution is chosen as an arbitral institution, the arbitral institution cannot go into any question of legality, validity, limitation at the time of appointment of an arbitrator. But under 11(6), the court has decided that it can go into such questions. According to me, this power to say there is a judicial power delays the decision-making process of appointing an arbitrator. The earlier view in Konkan Railways probably was a better view, but we can't help it out as of now. That is the judgment. There is another important aspect. In para 17 of Patel Engineering, the court has said that even if the court has to designate an institution for appointment of an arbitrator, it is only to give the recommendation to the court, as the judicial functions cannot be delegated to an institution. Now in the 2015 amendment in the Arbitration and Conciliation Act, Section 6B has been inserted in Section 11 to say that the designation of an arbitral institution or designation of an arbiter or delegation of the power is not a judicial function, it is an administrative function. But some or the other, this amendment has not been really argued in any matter. So what I think is that the courts have really stood with the cause of arbitration. They have taken progressive view in respect of seat of arbitration, in respect of execution of the award. But certain issues still arise because of the vastness of the country, the nature of litigation which comes to the court in different forums. Except Delhi High Court, which has a dedicated bench for arbitration matters, probably no other High Court has a dedicated bench for deciding commercial matters, which, same bench will be hearing the other civil matters or criminal matters along with the arbitration matters. The arbitration matters actually take a back seat because the priority was on the human rights or the issue of the convicts who are undergoing sentence. So therefore, broadly, the courts have stood with the cause of arbitration, but certain issues are required to be sorted out regarding the appointment of an arbitrator. It is grossly delayed in some jurisdictions. It takes about 3 to 4 years for appointment of an arbitrator. And then Section 34 will come into the picture, which again takes substantive time, and then in certain jurisdictions, there is intra-court appeal, then there is appeal to the Supreme Court. There are multiple forums of appeal needs to be reduced so that the litigant gets a benefit. There is some criticism as to why the court is interfering with the arbitration awards. The commonly Delhi Metro is cited by many people that why the court has interfered with in a curative petition. I will not like to say anything about the merits of the matter, but the fact remains that you can't confer unlimited power on the arbitral tribunal to decide the way they want to decide. There has to be some provision for correction of the error, intentional or unintentional, or the legality, validity. All these questions require to be decided by some authority other than the arbitral institution. Therefore, power is there, but the court understands that in what matter that this power should be exercised. The court is well aware of its responsibility. Court is well aware of the limitation. Time and again, the courts have said that the power of the court under Section 34 is not appellate power, it is supervisory power. Supervisory power means that you will broadly see whether the award meets the challenge, there is any ground of, so apparent, so repulsive that where the court finds inclined to interfere with the matter. So that's what I'd like to say.
Thank you, sir. That's very, very well put. And next, we turn to Mr. Sahil Naran, deeply involved in both domestic and international commercial litigation and arbitration. He brings a practical approach to this discussion. Mr. Naran, what strategies have you found to be the most effective in ensuring that commercial arbitration remains a viable alternative to traditional litigation for resolving complex commercial disputes? So please.
Thank you so much, Param. I hope I'm audible.
Yes. Okay.
Firstly, I think I wish to congratulate the institution, for organizing this. I have judged a few moot courts, and I was honored enough to judge one of them with Justice Gupta also in the recent past. So it's an honor to be with the esteemed panelists here, Justice Gupta, Shruti, who's been a former colleague of mine, and Param, and everyone else here. Keeping in mind that, of course, we are, addressing mostly students or, young budding lawyers, I will try and, keep it as simple as possible. While Justice Gupta has very fairly and, in a very nice manner, tried to give us both the, steps positive as well as negative, which the judiciary has taken in the past and recently, which have gone, to a great extent to improve the arbitration scenario in India. And Sir also is heading IIAC as of now, which is, of course, a very good institution. And we are looking forward, of course, to that institution and others becoming more popular in India. So, I was just looking at some data yesterday, while preparing for this. And I found out that, our court system actually is very clogged as of today. I mean, I was looking at the data from Bombay High Court and Delhi High Court. There are over 7 lakh cases which are pending in the Bombay High Court. In Delhi High Court, there are more than 1 lakh cases which are pending. And these are all small numbers, right? I mean, if you look at the entire country as Justice Gupta put it, we are a huge, vast country, and the numbers would be very big. So therefore, it is clear that arbitration as a means of ADR must step up and should fill the void. And therefore, I feel that to fill this void, it has to become more effective as compared to the traditional litigation, and that's where certain strategies which come into play, which you have to devise and you have to accept to make arbitration more effective. And I believe that all of this starts at the very starting. And I would put all of this in 4 buckets. The first bucket being the contract. You have to pay attention to the contract. The contract has to be appropriately drafted. A poorly drafted contract, a poorly drafted arbitration clause in a contract can be a source of multiplicity of litigations. So we were a part of a litigation, a Section 11, which was filed in the Supreme Court, recently. And I can even name that case. It is Balasore alloys. In that case, the Supreme Court was confronted with the existence of 2 conflicting arbitration clauses in, an umbrella agreement and purchase orders, which were, there in the umbrella agreement. While the former agreement was seated in London, the latter was seated in India. So this, of course, dispute was put to rest by the Honorable Supreme Court by applying the test which was laid down in a case, Olympus Superstructures, which gives primacy to the parent agreement. But of course, I mean, all of this could have been avoided, all this litigation, the rounds of arguments by counsel from both sides would have been avoided if the contract would have been clearer. So I think that is the first and the foremost strategy. The second strategy, which I take a cue from Justice Gupta, where he was talking about some jurisdictions which are more mature in India, such as Delhi. We have, Bombay, but of course, Bombay as of today doesn't fare as well, as Delhi in commercial matters and in arbitration matters. In certain jurisdictions, the appointment also, doesn't take place for 2 years, maybe 3 years or 4 years. So I believe that it's always important to choose your jurisdiction wisely if it is a domestic arbitration. And of course, if it is a foreign seated arbitration, again, you have to have proper legal advice to see which country, which seat is best suited for your client. I've had an opportunity to appear before various courts, across jurisdictions, and I can name a few. I have seen serious challenges in those jurisdictions. Such as I appeared very recently in a Section 9 in Lucknow in a commercial court. And of course, I mean, my experience was not that great. I also appeared in Section 9 in Jaipur. Again, a very similar experience. Another one in Kollam. I can name like quite a few, but all these jurisdictions were very tough, for a practitioner. And therefore, I feel that there's a lot that needs to be done at all levels, including, at the level of the institution where students, they are taught properly, then at the level of lawyers who are again taught properly, and there is a capacity building done, and at the level of the judiciary, at the level of the institutions, I think a lot needs to be done there. So, and 2 more points, of course, and I'm mindful of the time. I just wanted to also, add the bit of technology, that you have to leverage technology to make arbitration more effective. I understand that the courts these days are becoming more tech savvy. In Delhi High Court, we see that most of the judges and lawyers, they use their laptops or tablets these days, or iPads. Even in Supreme Court, we see, I mean, that has happened. But I believe that that still can be done in the ADR space, in the arbitration space. And like, I'll give an example. We are doing a very heavy arbitration where there are about 40 or 50 participants in total in an arbitration. There, if we have to book a place, I mean, we have to book a banquet hall physically. So usually what we do is that we have the hearing virtually, and where three arbitrators and all the parties, they can be accommodated properly. So I believe it is more cost effective. It avoids exorbitant costs of lawyers, the travel costs, the venue cost, etc. Then of course, moving on to my last point, I feel that we as lawyers, and of course our clients, and that's our duty to advise our clients, to tell them to maintain and enforce timelines. I think that's extremely important. We see that arbitrations are delayed. Thankfully, there had been an amendment in 2015 where some timelines were brought in. But still, I'm doing a case which dates back to 90s, right? And the arbitration is still going on. For one reason or the other, the time is extended. Of course, there have been certain other circumstances, but yes, that's one thing. So I believe that the parties and the lawyers should agree to fix dates in advance, maybe exercise discretion on extension of timelines, which is of course, I understand difficult because one or the other parties usually has a differing view. But certainly, and at the very same time, the arbitrators can ensure that frivolous applications are dismissed summarily without giving such applicants the power to derail the process. And the procedural orders need to be very clear so that the timelines can be met properly. Of course, I'm mindful of the time, therefore I have a lot to add, but I think with this, Param, I'll rest my answer.
That's very good. And I personally believe that people do prefer online and the role of technology in litigation and even in ADR. And well, finally, we move on to Ms. Shruti. Ms. Shruti Khanijo brings her experience in representing parties in high-stake arbitrations across international jurisdictions to the table. So, Ms. Khanijo, how do you perceive the effectiveness of arbitration in handling disputes within sectors like infrastructure and energy? And are there specific industry practices that arbitration tribunals should adopt to enhance their outcomes? Please.
Thanks, Param. And thank you to the university and the center. Congratulations on organizing a great event. And thank you to my co-panelists for sharing their views, specifically Justice Gupta and Mr. Sahil Narang, who I've had the pleasure of working with while I was at Khaitan. This is a very apt question, and I think we're asking the right questions at the right time here, specifically because last year, in fact, earlier this year, there was an arbitration committee report that actually also talks about how and discusses how different sectors require different expertise and different expectations. I'll just go back a little bit and look at it from a very policy standpoint. What is it that, and why is it that arbitration really even started? The first was to give effective and efficient solution to resolving disputes, specifically commercial disputes, outside of the state court system. And why did that become necessary? In international context specifically, it became necessary because there are different parties from different jurisdictions who would expect certain level of customization in terms of efficiency. And what was that? That was cost efficiency, that was specific skill set in specialized subjects like infrastructure or construction industry, and the timelines that would be brought on the table so that the commercial issues are resolved in time and more effectively as compared to going to the state court systems. That said, it's not that state court systems weren't able to deliver these. It's just that for specialized sectors such as construction, infrastructure, or any other sector, including IT, for even IP disputes, which can be arbitrated, these disputes were better resolved. One in behind closed door, where arbitrators who are experts in these areas resolve it. Confidentiality is not lost. Then the trust and confidence in the whole system remains as such. the quality of discourse that happens and the quality of adjudication in these arbitrations is comparatively more nuanced, given the fact that the courts in India are quite burdened. So a specific concentration or specific focus to resolving the dispute efficiently in those timelines can be given. So that said, the reason why I think effectiveness, how does the effectiveness of these disputes, which are specialized, is impacted in India, is one because of I think skill. We're in a jurisdiction where skill development is a very given premium, and given the fact that in our population, in our educational mindset, we do believe in it. One of the important factors, I think, which will be very important in developing and enhancing the effectiveness of arbitration in construction industry would be skill development of both the arbitrators, and second of both at the council level as well. Involvement of the experts in resolving disputes which require their expertise. That's something in my practice I've seen quite differently and move on in terms of the past decade in India. When I joined the profession, I don't think a lot of experts were involved, specifically in disputes in construction industry, where a small delay gap had to be examined from a lens of when the dispute started to when it actually fructified and came before the arbitral tribunal. But that scenario is changing. And given that experts are also now involved in understanding the expert issues, so that assists arbitral tribunals as well, which are judicially examining the issues to be able to deliver better results. Second, in construction arbitrations, the time usually the companies itself are quite saddled with the awards because of the disputes itself, a lot of cost burden is impacting the companies. So this efficiency of time is very important, which our law now recognizes. And with the coming in of courts like Justice Gupta and even Mr. Narang had mentioned, becoming more aware of how the judicial support is required for such disputes, these disputes are getting the support that they require to be resolved out of court. That said, I think a lot of discussion today is on how can we make arbitration effective. And that discussion is also coming from the fact that there is a sentiment of arbitration fatigue that's brought in. Arbitration became a lot more popular for commercial disputes because a litigation fatigue was setting in. But at the present moment, if we look at how other jurisdictions are really involved, specifically on commercial disputes front, we can clearly see that the jurisdiction has evolved based on the kind of disputes it had. So if we are talking about London, London's evolved as a hub of commercial disputes because a lot of commercial contracts historically have had common law provisions, have had English law as their governing law and as their substantive law of contract. And those disputes were resolved in London, whether it were domestic to the UK, whether it was Europe, whose disputes were referred there, or was it international. So according to that, the skill set of people also developed around it. Now, when we look at India, India had the advantage and disadvantage of having Singapore right next to it, where already there is a set system of having done extremely efficient arbitration mechanisms. They have SIAC, which is the arbitration center. To support it, they have an international court to also support it with pre-arbitration mechanisms, or in fact, during arbitration mediation services, which is SIMC. So they also provide a whole set of these services so that you have a complete dispute resolution system starting from a pre-discussion to the end where you have to enforce an award and go for realization of that amount. So in disputes like construction, that's very important because the realization of that locked asset value of that is an award becomes quicker. For India to evolve to that level, specifically in the present modern day and time, it's important to also recognize that that dispute resolution system has to be provided, not just on the national level, but in a granular, more state level and then district court level, because commercial contracts, specifically construction or infrastructure contracts, they range from perhaps a 50 crore contract to innumerable disputes contracts of 1,000 crores. So in that sense, this point has already been covered by Justice Gupta and Mr. Naring, so I'm not going to belabor it again. But in my experience, again, I've seen very recently there was a matter where both the parties, commercial parties, both of them big companies based out of Chennai. The disputes subject matter is also based out in Chennai, and everything happened in Chennai. There's no relationship of that dispute to any other place. But the parties, while drafting contract, had put, and I wouldn't like to call it mindless, had put inadvertently New Delhi as the seat of arbitration. Now the parties, because one of the parties, of course, is the party that's suing, the other party does not have a counterclaim. So the party who is in fact the claimant does not want to travel to Delhi because it's extreme incurrence of costs. The counterparty is not really agreeable to do it virtually. It's not agreeable to do it, move the seat to Chennai. So that in effect becomes a cost issue for them. Sahil already touched it in his response, that while drafting of contracts, it has to be very important that the parties understand where that contract is being discharged. That really improves upon the efficiency. Now, when we talk about institutionalization, institutions also help here because institutions provide you with a particular clause that can be incorporated in your contract as a dispute resolution mechanism. And when you do involve that specific clause in your contracts, it makes you think at that time, what are your requirements? Perhaps that's the time where institutions also help you indirectly, for you to think about it and look at it properly. Institutions also help understand, even at the time of entering into a contract, what the rules really provide. And I've seen a lot of mature commercial parties asking questions specifically in India and not just outside India. What are the rules that will go best with my contract? And that's a shift in the entire system that has come in over the past 2-3 years. I think a lot of it is also contributed to the fact that institutionalization has really picked up in India, in good amount, because the courts have also supported it quite a bit. So in that sense, the outcomes have changed over the past decade, rounding up in terms of what your question was, Pranav. The outcomes have changed because of the judicial support provided, because of the government also stepping up in enabling the arbitration infrastructure, as well as the arbitration culture in India to evolve. It's also because skill building has improved in terms of arbitrators, education of lawyers across the country, and also the user interface in terms of the corporations which are using arbitration. They're becoming more and more aware of what are the best means to resolve their disputes, even while using arbitration. Thank you.
Thank you so much for the insightful opinion. And so far, we talked about effectiveness and the strategies and the practices for commercial arbitration and the role or necessity of judicial intervention. So now moving forward, we will talk about the challenges being faced by commercial arbitration, which is our second sub-theme. We will start with Justice Hemant Gupta, sir. Sir, from your judicial perspective, what do you consider to be the most significant challenge currently facing commercial arbitration in India? And how can the legal framework be strengthened to address these issues, particularly in terms of maybe enforceability of arbitral awards? Sir, please. Sir, you are on mute.
Sorry.
Yes, sir.
Thanks, Param. It's the most difficult situation which India is facing now, that how to improve the commercial arbitration ecosystem. I broadly divide the arbitration system in 3 parts. First is pre-arbitration system, where the appointment of arbitrator is concerned. Then arbitration process, where the award is ultimately rendered. And then post-award. Then objections, enforceability are 2 parts of it. some things we can handle it. Institution can handle it. Pre-appointment of an arbitrator, the institutions can handle it. Arbitration proceedings, the institution can oversee it. But post-award is a matter which falls within the exclusive jurisdiction of the court. How to deal with that, that is the biggest challenge. The courts, as my co-panelists have already said, that courts are overburdened. They are heavy docket of each matter, constitutional issues, the legal, the property disputes, matrimonial disputes, and the criminal disputes. The arbitration or the commercial disputes rank at the bottom of the pending cases. But all cases are important. Commercial disputes are important. So are the matrimonial matters are important. So as the tax matters are important. So as the criminal matters are important. Then a balance has to be struck that all matters are taken up in a reasonable number every day, so that ultimately the disposal is there. I again say that Delhi High Court is the only exception, which according to me, maybe there are other high courts which have a dedicated bench for commercial matters, which have a dedicated bench for criminal matters, and so on and so forth. So each matter is given due importance. So according to me, the problem with our in respect of enforceability of arbitration award is multiple forums of appeal, and also the vagueness in the grounds of challenge, that like a fundamental policy of Indian law. How do you define this? Then the courts have intervened to say patent illegality. These are all grounds which probably can be better tweaked to be more specific, that on what grounds you can challenge the award. I think Section 34 of Arbitration Act 1940 was more precise in the grounds of challenge. And actually, we have all grown with the 1940 Act. So we knew that what is the ground of challenge. Even if there are two views are possible, the court will not interfere. The court will only go to the question if there is it's against the express terms of the contract. Those things should be made explicit in Section 34. And enforceability of award is again an issue. Enforceability of award means that the parties will be again in court, because generally in India, they said the problem of the decree holder starts after he gets a decree. So my suggestion at one point of time was that probably second schedule of Income Tax Act should be applied, extended to enforce the arbitration award. That's a summary procedure, but a reasonably effective system of recovery. That can be one way of looking at the enforceability of award. There is a difficulty of enforceability of award, and we are basically, very litigating mind. We want to fight everything, more so public sector undertakings. They don't want to give up anything. There is a lack of decision-making process in the public sector undertakings. And then somebody has to take up the call, that no more appeal. That is not the situation with the public sector undertakings. The large awards, large contracts are given by public sector undertakings alone. India is a developing country, economy is booming, the infrastructure is being created. So infrastructure has to be created only by public sector undertakings. The oil exploration, gas pipeline cases, there are thousands of crores of disputes. This matter required to be handled with care. You can't handle it in an ordinary civil court mentality that one objection, second objection, third objection, it will not work out in the commercial system. We have to be precise. The courts have to take a quick decision and not welcome the multiple objections. The quickness in deciding the objections is the key key of all resolution of disputes. The delay is in fact benefiting the judgment debtor. In one of the conferences I was there, it says that even if the party is called upon to pay 100 crores after 6 years, he has made profit of 100 crores in 6 years. So he doesn't pay anything out of his own doing. He's paying because of the lack of, because of the funds which became available to him on account of delay. So that kind of a thing we should need to avoid. We have to be effective, and mindset needs to be changed. That is the biggest challenge. We should not litigate. Somebody should decide, more so in the case of public sector undertakings, that if there is an award, there should be in-house mechanism to review the decision, and they should be able to take a call whether to file appeal or objections or not, rather than unmindful of any consequences, file objections and delay and incur extra cost of fighting litigation, cost of interest, only because of somebody at the ministry level thought that's worth fighting a case. That needs to be curbed. Thank you, Param.
Thank you, sir. In principle, and I do agree with everybody who said about the delays and all the appeals, and that a person who is a debtor will eventually lose nothing at all. There would be no punishment. But moving on, we have Mr. Sahil Naran. So, given your involvement in disputes across various sectors, what challenges do you see in promoting the culture of arbitration in India? And to point out, especially with the recent move of the central government in June 2024, which restricted the usage of arbitration to low-value disputes. Can you please shed some light over that?
Yes, thank you so much, Param. Thank you for this question. I think largely the stage has been set by Justice Gupta, by covering most of the points. But just to, recapitulate and, reiterate those points, I believe that delays in the court system, that's the biggest culprit. And of course, some instances which are pointed out, by my co-panelists, the excessive interference in the arbitral proceedings by courts. And of course, I mean, this happens mostly, post the arbitral award, the third stage that was mentioned by Justice Gupta. So I mean, I would not want to say it, but yes, in the minds of investors, in the minds of foreign parties, India doesn't get an arbitration friendly tag sometimes, and with decisions like the one which Justice Gupta mentioned, the DMRC decision, where after a whole round of litigations, there was an award, there was a challenge, there was an appeal to that challenge, there was a Supreme Court SLP, there was a review, and then there was a curative. In the curative, they undo, and of course there was a flip-flop happening on each forum. So I believe that's certainly not giving India the arbitration friendly tag. And of course, certain cases were also mentioned that courts interfere in a 34 stage, and the scope is widened by the courts. And then there are delays at the 34 or the 37 stage, and in the case of foreign awards, in the case of Section 48, etc. Of course, the Commercial Courts Act, somehow tried to undo certain things because our courts are very overburdened. And recently they brought in a concept of pre-litigation mediation, because they thought that maybe litigation is not working, arbitration, there are certain issues, let's try mediation. So they brought pre-litigation mediation, which was made mandatory. But then the parties somehow have found a ingenious way that they file an interim application in court, and they can circumvent the process of mediation. Of course, I mean, the government is doing enough. They have come up with the Mediation Act, which is yet to be notified. Some provisions have come in, and I believe the provisions would come in. But there also, I mean, there are certain lacuna where certain disputes are mentioned in the schedule of the Mediation Act, which they say that are able to be mediated. But of course, I mean, there are certain disputes which cannot be mediated at all, and there's a huge list. So I believe, of course, arbitration has evolved to a greater level, and it is easier for us to, take arbitration to the next level rather than start afresh in mediation. And which also brings us, to this particular, the Ministry of Finance, this notification, which was issued on 4th of June of 2024. Whereby they recommended to states to restrict arbitration clauses in government contracts only to disputes worth less than 10 crores. And they cited that arbitration processes are expensive and time consuming, and more concerningly, the government is effectively withdrawing from the system due to perceptions of wrongdoing, including collusion. So I mean, this is very concerning, of course. Such a stance by the government does little to, remedy the systemic and perceptional issues that plague the arbitration framework in India. More concerningly, it signals a lack of confidence by the government about the possibility of curbing down on practices that make the arbitral process less conducive. So, of course, these are my views, which I try to just jot down and share with all of you. But I believe that there have been many steps which have been taken. 2015 amendment being the first one, and there have been certain other amendments. There have been some reports which have come in. Recently, an expert committee report also came in, which tries to somehow deal with certain aspects. And I'll just name 2 or 3 of them, which would be good. One is, administrative assistance, taking techno-legal, assistance in arbitrations, wherein you have, technology being used at every step, including, say, transcription services, which saves a lot of time and cost when it comes to cross-examination. Then coming to, making a provision for virtual mode, arbitrations conducted by virtual mode. Also, I mean, I was looking at another section they proposed, 12A, wherein they say that the institutions, which are, of course, now growing in India, our own institutions, domestic institutions. One such institution is headed by Justice Gupta here, to bring independence and impartiality and some kinds of standards that those institutions. So I believe I mean, some action needs to be taken pursuant to the expert report, and certainly I feel that this notification needs to either be revisited or withdrawn.
Param, can I say just one thing, add to this?
Please, sir, please. Definitely, sir.
My experience is that if there is some judgment or some decision like this notification, they don't stand for long. Like NN Global was overruled in 6 months' time. Wait for 6 months, probably it may not stand.
Sir, if I may just also add one point, sir. A few days ago, the Honorable Supreme Court has issued notice in a matter where the clause says that there is a restriction on arbitrating if the dispute is beyond a particular amount. And there the Supreme Court is already looking at it, sir. So therefore, this notice will also go. You rightly said so. I mean, this may very well go.
That will be different. If there is an arbitration clause, then you can't restrict it. If the arbitration clause itself restricted, the situation will be different. But we need not go into that question. Basically, these are odd circulars which are against the common sense. Generally, they don't stand for a long time.
I appreciate that.
Very well put, sir. Very well put. And thank you, Sahil, sir, for bringing mediation into the topic. That's something we at Mediate Guru do, promote mediation and try to bring the young generation into mediation and get more people acquainted with it. And well, since we're talking about mediation, I would like to ask Ms. Shruti a question. How do you see mediation gaining where arbitration is somehow losing as a popular choice between those? So, what do you think?
Thanks, Param. I think this was this is a very interesting question, specifically when they're discussing effectiveness of arbitration. So, I think mediation and arbitration both cater to the same issue. One is where there is a commercial relationship that's gone wrong. The outcome obviously has to be one, the resolution of that relationship to come to a amicable solution. That can come through mediation, arbitration, or appropriately litigation. It's just a matter of choosing which means is the most effective. Now, I don't think arbitration is completely losing out. We know that there's a circular that the government has come up with. After that circular, in fact, there was a question that was submitted to the parliament and was responded to. In one of the questions was, what is the reason, what is the rationale of why this notifications really come in? I'll just give a background of what this notification is for the benefit of audience. This notification essentially says that in the government dispute, in the disputes where the government is involved, when they're drafting contracts specifically for procurement, it's very important for them to consider mediation as their first choice in contracts which are above 10 crores. One. And second, amongst other things, it also says that if you do want to include arbitration, it's not that it's not permitted. You do have to go through some checks and balances and have that specifically approved. So the process of incorporating arbitration clauses has become difficult. It's not a given now as it used to be. So I'd say that inadvertent at times inclusion of arbitration clause will definitely go away now from government procurement contracts. And coming back to the parliamentary question that was asked, it was responded to by the ministry, and the ministry said that the reason simply is that the government has found arbitration unsatisfactory. Why? Because NHAI's data suggests that almost 60% of the awards go up to courts in challenge. So that's a fair amount of money that's involved. That's a lot of contracts. And you know what happens specifically when we think about, let's say, procurement contracts, and let me also take the specific example of NHAI. It's a construction industry, right? Anybody on the counterparty side, which will be a private contractor, that private contractor might only have 5 NHAI contracts, and all those 5 contracts in which they were supposed to recover some money are now awards that are fructified, but still stuck in courts. Now, we don't know how long that effective time will be for them to resolve it. In the meanwhile, when you think about that private contractor is not able to sustain his or her business, and that business goes into insolvency. So what are we here looking at? We're looking at a system where commercial relationships are established through contracts. Government is one of the parties. There are arbitrations where a lot of investment in terms of time, cost goes in, but the ultimate outcome is still before courts. So one, I think the government has taken a stand now that it will not challenge it as often as it used to, but because that had not worked out as well. So it is also promoting mediation in terms of where certain disputes can be resolved at the mediation stage, should, and if the parties while entering into a contract believe that arbitration is also one of the resolution mechanisms they want to incorporate in the contract, they should. I mean, of course, these circulars and these notifications do remain to be tested by courts in cases that will probably come up soon. But the government is also educating their persons, including the ministries, the PSUs, the other enterprises, by giving them trainings now. Now, coming to a question and directly responding to it, is mediation gaining where arbitration is losing out? I don't think arbitration is losing out. I think arbitration has its place reserved where it always should have. It's just that the effectiveness of arbitration depends on how effective your contract is, how effectively you undertake it, and where you choose to enforce it. And one of the biggest reasons why its effectiveness has been lost is, as Justice Gupta had already brought it in the first and the second response, is because there is a lot of challenge that has been made. And if you make a challenge before courts, the courts have to examine it. It's not that the courts will not look at it from the perspective of what is the law applicable. So it's the decision and the change in mindset of the parties. That's where mediation comes in. Mediation is a non-adjudicatory process. For the benefit of the audience, again, mediation is not a mediator sitting in decision over your dispute. The mediator sits as a neutral evaluator or a facilitator in a facilitator capacity. Both parties come sit across the table, they discuss their dispute, issues are evolved, and from that issue, solutions are coming. And that the outcome of that entire resolution process is a settlement agreement. It's not an award that is binding on you. So in that sense, the whole scenario and the system is being focused towards resolving a dispute before it becomes adversarial in nature, because arbitration itself is also an adversarial process. So I wouldn't say that mediation is gaining where arbitration is losing. Mediation has always been present, but mediation's effective incorporation in India as a culture of resolving disputes has come in now. If you look at the Commercial Disputes, Commercial Courts Act, since 2018, pre-litigation mandatory mediation reference is present there. So, of course, there are exceptions to it. For example, if you need an interim relief, you do go to the court, circumventing that process, bypassing that process. So in that sense, the government, the court system, they're well prepared for commercial disputes to be resolved through mediation even before they reach the court. The same thing, in my experience, applies for commercial disputes through contracts as well. A lot of contracts in India and international contracts which have high stakes do provide for mediation as the first step of dispute resolution. Now, if you look at institutions, I'm not sure about all institutions in India, but institutions across the world, including, and I've benefited it at SIAC and ICC, excuse me, they provide for protocols. For example, Med-ARB protocol or ARB-Med protocol, and even international courts provide for Lit-ARB, Lit-Med protocols. So what does that mean? That simply means that in case and while you're arbitrating a dispute in an institutional setting, and you do believe, the parties believe that mediation might be a good resolution point, this may be a good resolution point to refer the matter to mediation to see if we can actually resolve it out of the formal adjudicatory process. So what will the institution do? The institution and the arbitrator will be requested perhaps by both the parties that we want to take this matter to mediation. And it will be referred to mediation in the same institutional process. So the same amount that you've given for arbitration, that gets diverted to resolving the dispute through mediation at whatever stage it could be. So in that sense, mediation has already been there internationally. It's being used very effectively in two of my highly contentious construction disputes at different stages. Mediation has come to the rescue, and the matter has been resolved with a settlement agreement being enforced as as arbitral award, because the matter went back to arbitration and it got settled through a consent award, the settlement agreement. But that said, mediation is very popular across the world as an additional resolution mechanism and not just alternative. And talking from a very strategic perspective, when we look at disputes being resolved, a lot of times it's not clear to the parties in the beginning what the merits of their disputes are. We as people, and of course, the corporate disputes always also involve people, right? We as people believe that our dispute is highly tilted in our favor and the counterparty is wrong. But as the parties go through the whole dispute resolution process, they do realize and they do also understand the counterparty's merits and demerits in the case. So let's say after a cross-examination stage, a lot of times a party which may have believed that their case has a lot of merit may not think so completely. They might think, oh yes, my case has merit, but maybe it's not 100%, it's a 60%. Why don't I discuss this in a formal mechanism to be able to reach a better solution as compared to what binding arbitral award will give me? So in that sense, I think you're in the right space. Mediation is not completely gaining where arbitration is losing, but mediation has its own place and it's always been there. It's just that mediation is becoming mainstream in India with the enactment of Mediation Act now. Thank you.
Very well put. And we hope that mainstream mediation gets here sooner rather than later. And well, with that, we are on our final sub-theme, that is to explore whether institution arbitration can effectively address the challenges we have discussed. And now this question is for all the panelists, as Hemant sir is the chairperson of an institution arbitration center, and both Mr. Narang and Ms. Tharijo have worked with them. So the question is, what are your thoughts on the role of institution arbitration, and what's their role in addressing the challenges faced by ad hoc arbitration in India? And can institution arbitration bring about a more structured and predictable dispute resolution environment? Hemant sir, if you can go first. Sir, you are on mute. Thank you.
It automatically gets mute. Anyway, thanks, Param. You know, this is the most important question in today's ecosystem, arbitration ecosystem. Unfortunately, we have grown with the system of ad hoc arbitration. Under the 1940 Act, again, this was the court was appointing arbitrator. So that process continues under the 1996 Act also. So to change the mindset from that ad hoc arbitration to institutional arbitration, mindset is the most difficult thing to change. You know, you can change other things by law, but mindset you can't change. Ad hoc arbitration has a lot of limitations or challenges. There is no timeline. There is a force schedule, but force schedule is applicable only in a limited cases, and the parties with expert advice from the councils can always circumvent that force schedule. Mr. Narang and Ms. Shruti will follow this very well. Though there is no timeline before for the ad hoc arbitrator, there is no fee structure, although force schedule is in a way applicable, but generally it may not be applicable. So that because of delay and the fee which is charged by the arbitrator, the ad hoc arbitration gets a bad name. And because of that bad name, the entire arbitration ecosystem gets bad name. It is not only the litigant will not know that is ad hoc arbitration or institutional arbitration. He knows only that he has gone for arbitration and this is what has costed him, or this is what has delayed it. I understand there are cases which are pending before the arbitrator for more than 10 years. You don't take that kind of a time before the arbitrator. But the institutional arbitration, on the other hand, has a fixed time schedule of conduct of arbitration, fixed fee from the day one that that this is the fee which will be payable. There is an oversight by the institution that how the arbitration is to be conducted. There is somebody watching the arbitral tribunal's proceedings, which is not true in ad hoc arbitration. You know, there are ways of dealing with it. Recently, I would say that we came out with MSME regulations. MSME is one sector which is a completely badly stressed sector. It contributes 29% of India's GDP, but still they are the most stressed sector. So we came out with the regulations, especially for MSME sector, providing legal aid to the stressed sector. You know, in a commercial world, it is unheard of that legal aid will be provided. We have also come out with the regulations that anybody sitting anywhere, say Tamil Nadu person can file a complaint or a claim in Tamil, which will translate it in English by digital software developed by the Government of India under the Digital India initiative called Bhashini. So 14 languages can be translated by the software into the English, and the speech can also be translated speech to text, speech to speech. These are all can be translated A person in Tamil Nadu can argue in Tamil, we'll hear it in English. So that kind of a facility is available. That's what we are providing. That will actually motivate people to opt for institutional arbitration rather than the ad hoc arbitration. The difficulty is that we think that the burden of propagating institutional arbitration is on one person or one institution. We have to change our mindset. Everybody in this country has to think that institutions should be promoted for arbitration. Unless we as a country think alike for promoting institutional arbitration, the institutional arbitration will not come out, will not stay. People have giving example of Singapore. Singapore started with the institutional arbitration way back in 1990. We are late. We are late by 30 years. Where we have thought of institutional arbitration, there were institutions like Indian Council of Arbitration in 1965. It started, but some or the other, probably it could not occupy the space of institutional arbitration in the country. There are other institutions which are occupying some smaller space, but the major space is still available for the parties, for the institutions to occupy. So if we as a country, we as a litigant, we as a person responsible for developing arbitration ecosystem, think that we have to promote institutional arbitration, that is the way forward for instilling confidence of the litigant in the arbitration. We have to think alike. That's what I would like to say. Thank you.
Very well put, sir. Very well. I remember I saw the notification from IIAC, I guess, few weeks back, and unfortunately, I can't recall the whole of the document. But what things struck most to me was that the arbitrator would have 6 months to resolve the dispute, and for me, that was something huge.
That's
and
right.
Something amazing.
We have made fast track procedure. There's no evidence, on the basis of pleadings alone will decide.
Right.
So that way, evidence is mostly in the commercial dispute, evidence is not required.
Right.
Because the documents, all are documents, no oral evidence. Maybe in case of proving of liquidated damages, evidence may be required, but otherwise will not be.
That's amazing, sir. Moving forward, Mr. Sahil, can you share your views?
Yeah, sure. So, of course, Justice Gupta said that we are late by 30 years, but they say that der hai durust hai. So I believe that, with institutional arbitration increasing in India, of course, and across the globe, I was just putting down certain data sets, and I thought it'll be good for me to share that, since, I have looked at some of the data points. So in 2023, SIAC, which is in Singapore, it's one of the institutions, it had its second highest ever caseload with 663 new cases. Similarly, LCI also recorded a upward trajectory, of new cases. It rose from 249 in 2018 to 339 in 2023. Of course, I mean, there are certain other institutions. I have all the data points. ICC also saw, a huge rise in the number of disputes. Similarly, we see other institutions globally. But in India, of course, I could not get much of the data, but I got a data of MCIA, and it is slightly dated, but I thought I'll share it with everybody, that since inception, MCIA has administered 83 cases as of now. And of course, I mean, the government has taken a note of it, and in various reports, they've said that institutional arbitration needs to be pushed. And one such step was the formation of the center, the IIAC, by way of central enactment, which is a welcome move. Now, I also happened to see a report by PwC, which is about a decade-old report, wherein they asked people that whether they prefer ad hoc or they prefer arbitration, institutional arbitration. Of course, it was quite a long time ago. And surprisingly, at that point of time, the people who said that ad hoc is preferred were 47% of the respondents. And 40% at that point said that yes, institutional arbitration has to is our preferred mode. And some said we are neutral. And we as a firm, Khaitan and Co did a survey very recently, and we found out that it has not changed much. But institutional arbitration, the respondents who preferred that have increased from 47 a decade ago to only 57%. So still there is a lot of improvement, I feel. And of course, I believe that mostly, of course, some of the points have been touched upon by Justice Gupta, but I feel that ad hoc, of course, people don't realize when they get into it that it may be very costly for them. And at the very same time, since an institution is involved, they feel that it is very costly. They always feel that institutions so bahut महंगा होगा. So, and that's the first question they ask us, as lawyers, that institution hai, it'll be very, very expensive, especially the foreign institutions. So here I believe that we as lawyers need to tell our clients that there are tools which are available today, such as there are cost calculators on various websites of these institutions, where we can very well go to those websites, check how much will be the cost, because as Mr. Gupta, Justice Gupta also pointed out, that these costs are always regulated when you are going to an institution, but in an ad hoc setup, costs may be very, very high. And there is also, an issue of timelines, going crazy. So that's, I think, a very big problem which I wanted to highlight in institutional, arbitration. Of course, there are certain advantages which have been touched upon, but I feel, maybe Shruti can add to that, Param. I believe, the advantages which are there, or anything else that Shruti wants to add.
Yes, perfect. And Ms. Shruti, if you can just quickly summarize and share your opinions, please.
Yeah, thank you so much, Param. And I think a lot of good things have already been mentioned by Justice Gupta and Mr. Narang. I'll just try to summarize in terms of what my thoughts perhaps after listening to both Justice Gupta and Mr. Narang are. When we look at institutional arbitration, or any arbitration for that matter, the quality of that arbitration depends on who the arbitrators are. So I think effectiveness of arbitration overall, that's the theme of the present discussion, totally and truly depends on how you appoint the arbitrator and who is it that you put in charge of delivering the result and the outcome to you, which is in the sense of your arbitral award. A lot of times in ad hoc arbitrations, and that's particularly been my experience over the past 10 years, is that if you have an arbitrator who is very, on a real-time basis, alive to the realities of the commercial dispute, they are very quick in understanding it. Second, they really control the delays that are usually attached to arbitration processes. So that quality of arbitration discourse really makes a lot of difference here. Second, I think institutions, since the time they've really come up, and I'm not just talking about international institutions, Indian institutions as well, Indian institutions have changed how even ad hoc arbitrations take place. For example, if you do put institutional arbitration clauses, there are the same arbitrators who would operate in ad hoc situations. They do understand, and they're also getting trained how arbitration institutions are changing the scenario. For example, if we look at arbitrators who do both international and Indian arbitrations on a regular basis, they bring in those best practices into ad hoc arbitrations as well now. So similarly, Indian institutions, even if ad hoc continues to be preferred mode of dispute resolution. Indian institutions, by their training, by conducting these arbitrations for different parties, appointing the same arbitrators, are improving the whole effectiveness of the infrastructure, the whole culture of arbitration as compared to what it existed earlier. So I think institutionalization is one of the most important aspect and one of the best things that have happened to arbitration over the past 5 years, because it has changed how the arbitration culture in India really operated. In my arbitrations itself, I've seen Indian arbitrators being very efficient, very quick. Justice Gupta mentioned about the fast track process that has been introduced in India through IIAC rules. And that's something which existed internationally in ICC, in SIAC, but it was not present in India, including under the Act earlier. So in that sense, that's something which is most beneficial. Justice Gupta also mentioned about documents only arbitration. A lot of my American clients, they prefer document only arbitration, because for them, documents only arbitration takes 3 to 4 months with an arbitrator, virtually specifically, and it's the quickest method of resolving disputes. Sometimes disputes are very heavy, very, very document intensive, which is absolutely correct. And that's where perhaps an expert report may be required. But that's one of the few cases. Most disputes that we see in India currently, as lawyers, as users of arbitration, are the disputes which are not very high stake or high value. Those are disputes which can be resolved very easily through documents only arbitration, through fast track means, and the awards can come up earlier. So I think I'll also go back and respond to your previous question here again. Is arbitration losing and mediation gaining? Again, arbitration is not losing because institutions exist now. They're improving the arbitration culture in India, and effectiveness is directly related and proportional to how institutions and the legislature views the arbitration culture in India needs to be evolved. Thank you. That's all from me.
Amazing. So I guess the right question should have been that, is litigation losing where ADR is gaining? But no worries. I'm confident that the insights and experiences of our distinguished panelists will provide us with a deeper understanding of these issues and inspire fruitful discussion. I encourage all the participants to engage actively and share your perspectives. And together, let's explore how we can promote the effectiveness of culture of commercial arbitration as well as mediation, because I have to promote mediation. Guilty as charged. I'll hand it over to the organizers.
Param, I believe there is a question on the chat box. And of course, that relates to your favorite topic, mediation.
Well, I will be biased in this, sir. So if you want to take this, please do.
Yeah, certainly. I mean, I'll just share a quick, response to that. Of course, I mean, there is no, preference over arbitration mediation generally, but I think mostly when, parties, they seek a less adversarial and, more collaborative kind of a resolution, they prefer mediation. And I mean, of course, these are the benefits of mediation that again I will, elaborate here. But I believe, mediation in a way rather than arbitration, which is adversarial, preserves relationships, better than arbitration, because there the parties actually have control over the process, and also they have control over the outcome. And certainly, of course, there is a flexibility which is associated to mediation, which again, is absent in arbitration. So I believe that, I mean, there is no specific dispute. I believe all the disputes are capable of being mediated, are capable of being arbitrated. But yes, these are some of the things, which are the benefits of mediation against arbitration.
Very well put. And just to put my 2 cents on it, I'll say all the disputes can be, resolved by mediation if you really want it to. And well, the only exceptions are constitutional or criminal. But if strictly talking about ADR disputes, I will say all the disputes or almost all the disputes can be resolved by mediation. Thank you. Okay, there is one more question, that is, how can the integration of AI transforms the effectiveness and efficiency of ADR? Anyone? How will AI play a role in ADR?
Well, I mean, Shruti, you want to take it?
Totally up to you.
Well, I believe, I mean, I can just, give my 2 cents. Of course, AI is the talk of the town, right? Everybody is talking about artificial intelligence these days. And I mean, I know for a fact that, my associates, they turn up the drafts so soon. I know because they're using maybe Chat GPT or something. And that's the reason we as a firm had to, make our own version of Chat GPT, which uses our own data, which is more secure, etc. So I believe certainly, I mean, AI is there to stay. AI will change the arbitration landscape quite a bit, and it has already done. I mean, I'll give an example. Uh, I mean, if you have a cross examination, and that cross examination usually in a normal ad hoc setup, what happens is that the counsel would ask a question to the witness. That question will be typed on the screen by a stenographer. That stenographer will then, I mean, the arbitrator will then correct that question. Then the witness will respond. That very thing will again happen. So I think a lot of time is wasted. So these transcription services, they are AI based, right? And the transcription happens real time. It happens real time, and only human element involved is that after the session or hearing, a person checks it with the recording and makes any changes, whatever is required. Very minor changes are required, and I've used quite a few of them. And there is one good Indian transcription service as well. I've used that also. Brilliant services. So that is an example of AI being used in arbitration. But of course, I mean, that time is yet to come, where a AI chatbot will, resolve disputes for parties. I'm not sure whether that is going to happen, because I think, as someone was putting it in the conversation I had last week, they said that in the times to come, IQ will not be important, but EQ will be. So a person, I mean, he may have, intelligence quotient, because that IQ can come from Chat GPT or, artificial intelligence also. But that emotional quotient of how you deal with people, how you, interact with them socially, in these kind of situations, how you present a particular case before an arbitral tribunal or a court. I think these are the facets which will change, and these will be the important factors in the times to come.
Very well put. Very well put. So, I, for one, I guess the Thetan launched their AI chatbot last month. I saw it, and really commendable.
Yes.
And I would like to ask the organizers to take over and ask if any other questions anyone has.
So there are no any other questions?
You can see which questions needed to be asked from the chatbots.
But I guess there's one more question in the chat box.
Go on. I guess the last one by Manisha is relevant. that is, given the multiplicity of proceedings, post-arbitration award can we infer that the arbitration system is slowly becoming just another litigation method? Anyone want to take that?
I think Justice Gupta is on mute. Sir, you're on mute. I can see
Sir, you're on mute, sir.
Yeah, multiplicity of proceedings, even in arbitration, will not partake the delays or the system of civil court. Civil court has multiple forums, multiple processes. Like in a civil suit, there will be an application for rejection of a plaint, then admission and denial, then so on and so forth. And then evidence, cross-examination. The arbitration is that way precise, concise, and there is delay only in respect of execution of objections and execution of the award. With little tweaking and little mindset of taking commercial matters at a priority basis, arbitration is still an effective way of resolving disputes rather than the disputes before the civil court. Delay, the time, the confidentiality, everything is important, is available in arbitration, which is not available in civil court. Civil court, everything is in public domain. Your plaint can be accessed firstly by the parties, and there is no prohibition with the party to make it public. But in the arbitration, there is a confidentiality is statutory made that you will not disclose the proceedings. The confidentiality is ensured. The quickness is there, but some delay post award, is something which is a judicial improvement in the functioning of the court. None of us can do anything. We have to only say that reduce the multiple forums of appeal. As of now, the objections are decided by one court, like say in non-metros like other than Delhi, it will be decided by principal court. The appeal will go to the High Court, and in some cases it will go to the intra-court appeal also, and then further appeal to the Supreme Court. These are multiple forums of appeal that needs to be reduced. One suggestion was that only objection should be entertained before the High Court. That is also not very conducive, because certain High Courts, that there is massive delay in deciding the objections also. So where one has to think innovatively how to decide objections in an effective and efficient manner.
Very well put, sir. Very well. Thank you, sir, for your response. And with that, I would hand it over to the organizers.
Sir, I guess there are 2 more questions in the chat box. Just like
can you take those? I unfortunately have to leave, and I would just convey my gratitude to Justice Gupta sir, Ms. Shruti, and Mr. Sai Naran for being here and encouraging us. And I would like to convey my thanks to Professor Dr. Tapan sir for giving me the opportunity to be here and interact with such distinguished panelists. Thank you so much.
I would also like to thank you, Advocate Param, for really giving such a good meaning to this discussion, and giving a very good directions to certain points, and really putting it the way it should have been. So thank you very much for being here. Thank you so much.
It's an honor. Thank you. Thank you, everyone. Thank you, sir.
Thank you, everyone.
Thank you all for your presence and participation, which made this event a great success. Now, I would like to call Professor Arun Kumar sir to present a vote of thanks to our esteemed panelists and all our virtual attendees.
Thank you, Pallavi. Am I audible?
Yes,
Pallavi,
sir.
am I audible? Yeah. Thank you very much. A very good evening to one and all. I feel honored and privileged to propose a vote of thanks on behalf of ICFI Law School, the ICFI University, Dehradun. I express my deep gratitude to all the panel members for their kind presence and a very insightful and enriching discussion on the topic promoting the effectiveness of the culture of commercial arbitration. I would like to thank all the honorable dignitaries on the panel and off the panel who blessed us with their gracious presence online to motivate all the participants. I express my heartfelt thanks to Honorable Mr. Justice Hemant Gupta sir, Chairman of IIAC, for his profound patronage in conduction of this academic program. We are highly obliged and extend our deepest gratitude to Ms. Reshma, founder, Leom Legal, Mr. Sahil Narang, partner, Khaitan Company, Ms. Shruti, partner, Shardul Amarchand Mangaldas and Company, Advocate Param Bhamra, founding partner, Mediate Guru, for sharing their insightful thoughts on how to promote the culture of commercial arbitration by highlighting its benefits, addressing current challenges, and exploring opportunities for growth and improvement. Appreciations for Advocate Param for moderating the panel discussion flawlessly and making it interesting.
I think there is some network issue. Yes.
I think we've lost Arun sir. There must be some network issue. I would like to thank Arun sir
Sir has
for
joined.
his kind
Sir has
words.
joined. Sir has
Now, I
joined.
would like to invite the student convener.
Sir has joined.
Okay.
Am I audible?
Yes, sir.
Yes.
Yes, there is some technical glitch. I, on behalf of the organizing committee, convey deep regards and hearty thanks to our Honorable Vice Chancellor, Professor Ram Karan Singh, for his generous consideration, continuous motivation, unconditional support, and valuable suggestion for conduction of this event. I am also thankful to the esteemed Registrar, Professor R.C. Ramola, who has been instrumental in obtaining all the necessary administrative support for organizing the event. My special thanks to respected Dean, ICFI Law School, Professor Dr. Tapan Chandola, for his constant help and guidance that radiate a source of energy within the members of the team. I express deepest gratitude to IT department for their extended support for smooth conduction of this program. I would also like to express deep appreciation for the overwhelming response from the participants. As we know, an event of this dimension cannot happen overnight. The wheel starts rolling months in advance. So, my heartiest congratulations to the Center of Excellence in Alternative Dispute Resolution for successful conduct of the program. We have been fortunate enough to be backed by a team of very motivated and dedicated faculty members and student committee. I thank everyone for the involvement they have shown and the willingness they have expressed to take on the completion of tasks beyond their comfort zones. My thanks also go to all who have given their precious time in organizing this panel discussion. Thank you very much.
Thank you for your kind words, sir. Now I would like to invite the student convener to declare this event closed.
Thank you so much, Pallavi. Before declaring this event closed, I, Soya Singh, student convener of Center for Excellence in Alternative Dispute Resolution Law, ICFA University, Dehradun, would like to extend the heartfelt gratitude to all of you for your invaluable contribution in this panel discussion. To our distinguished panelists, your expert insight and thought-provoking discussion have significantly enriched our understanding of commercial arbitration practices. Your willingness to share your knowledge and experience has left a lasting impact on our academic community. Our sincere appreciation is extended to Dean Sir and Assistant Dean Ma'am for their guidance and support throughout the event. Your leadership continue to inspire us to organize such enriching academic activities. To our faculty conveners, your tireless effort in this event, coordinating the entire program, were instrumental to this success. We acknowledge and appreciate your unwavering commitment, and thanks to all the faculty members who are present here with us and all the support they put on this event. We sincerely thanks to all the participants whose active discussion and thoughtful questions enriched the depth and the scope of this conversation. Your active involvement made this event truly interactive and beneficial for all. Last but not the least, special thanks to our organizing committee for their tireless effort and contribution. This panel discussion has been a collectively effort, and its success is a testament to the commitment of each one of you. I hope this event has cultivated a deeper understanding of commercial arbitration and will lead to further discussion and initiative in this way. Now, I declare this discussion as closed. Thank you so much, each one of you.
Thank you. Thank you all. Thank you to all the panelists
Thank you.
and all the participants.
Thank you.
Thank you.
Thank you, everyone.
Thank you all. Thank you.
Have a good evening.
Thank you, everyone.
My
I
pranam
would
to you.
request to everyone to switch on the camera so that we can take a screenshot of it.
Yeah.
Pallavi, can you take a screenshot of it? Pallavi, Sahil, Swayash.
Yes, ma'am.
I request everyone to please switch on their cameras. Done?
Done, ma'am.
Thank you all.
Thank you so much. Thank you.
Thank you.
Thank you all.
Thank you.
Everyone.
Thank
Have
you.
a good
Thank
day.
you.
Bye.
Ding dong.